What is probate, and why do most of my clients want to do whatever they can to avoid it? Hi, my name is Brandon Ayers. I'm an attorney, but I'm not your attorney. Today I want to talk to you about probate, what it is, what it isn't, and why most of my clients want to avoid it. At the end of this video, I'm hoping that you will have enough information you need to know if probate is right for you and your loved ones or not. We're going to get right into it this week, so let's have a seat, and we'll start to go through the probate process and why you might want to avoid having to go through it. All right, let's talk about probate. I want to start with talking to you about the process of probate. This is one of the three main objections that clients bring when they say, we want to avoid probate. And so the process is an important thing to understand of what your loved ones would have to go through if probate was required. Now, this is going to vary from state to state and sometimes even from county to county. So you should definitely consult with a local attorney in your area that you know, like, and trust to make decisions on advising you specifically. Again, this is educational for you, and I hope that it gives you enough information to have at least a good conversation with one of those attorneys. So, the probate process, what happens? Let's start with why it happens. Most states have rules about when you have to go through probate versus when your estate would not need to go through probate. And as we've covered in other videos, a big misconception for this is the presence of a will. A will in and of itself, in the vast majority of areas, will not do anything to avoid probate. All it will do is override the state's rules for what happens to your things when you're gone, which is still valuable, but is a big common misconception. So you go and you pass away, whether you have a will or you don't have a will. If your estate triggers probate thresholds, meaning the value of your estate is over those thresholds, then your estate is going to need to be probated. The alternative to this is a small estate. The vast majority of estates have small estate provisions that if you're under the probate thresholds, your estate can just be done with usually what's called a small estate affidavit, or in other words, a simple form that essentially takes your death certificate information, your bank account information, and allows an estate to be processed that way pretty easily. Now in Illinois, for example, the threshold for going into probate court is to have any real estate just in your name when you pass away, or having $100,000 of other stuff just in your name. So I've defined this in the past, but let's retouch on what this means, just in your name. Just in your name includes anything that doesn't have a joint account holder, so you don't have a spouse, for example, that's joint on a checking account. If you did, that checking account, when the first of you passed away, wouldn't exceed or count towards any kind of probate threshold. If you have a beneficiary on an account, like your retirement account or like on life insurance, the value of that account would not count towards any probate threshold as long as that beneficiary was alive or in existence. Things that are in trust are not just in your name. So the value of the things in trust would not trigger any probate threshold. So if you were to, say, have your house in a trust and an IRA with your kids on as the beneficiaries and an $80,000 between your checking and savings, and that's it in Illinois, and even if those checking and savings accounts were just in your name, those would be small enough for your kids to be able to use a small estate affidavit. They would not exceed the probate threshold. Even if the house was worth $1 million and the life insurance and IRA was worth $2 million. As long as those had beneficiaries on them and the house was in a trust, your checking and savings account would not trigger the probate threshold. And by the way, $100,000 is for Illinois. Most other states are smaller than that. I've seen $50,000, I've seen $75,000. That's one thing you definitely want to check in with your local attorneys to make sure you know what the probate threshold is, to see if it's a concern or not. Now, you're in probate court, you've gone over the threshold, you didn't have your house in a trust, or maybe you had a CD that wasn't in a trust and didn't have a beneficiary on it and it was worth $120,000. Now you're in probate. What happens? So when you pass away, when your remains or your body or whatever it might be in the circumstances of your death goes to a funeral home, the coroner's office. It issues a death certificate. So once that death certificate comes in with the date of your death, date of your birth, your address, your social security number, your cause of death, all those things that are on death certificates, that is what's going to be the first documentation you're going to need to start the probate process in most areas. It's going to have a lot of valuable information that you need, such as the date of death. Let's say you have a will. You're going to take that and the death certificate to the circuit court clerk, most of the time, of the county where you resided when you passed away. Your county of residence is one of the pieces of information that you're going to need from your death certificate. It may seem obvious, I know what county I live in, but on the death certificate, what if you were in a long-term care facility in a different county and your home was in another county? Which county is going to show up on the death certificate? I don't know. I would like to assume I knew, but I would just rely on the death certificate to come in and have that information for me. So you file your will in Illinois within 30 days of the date of your death, and you have that filed will as one of the documents you're going to need to open a probate, along with a bunch of other documents to act on behalf of an estate. At the end of that, what's going to be issued are letters of office or letters of administration, depending on the circumstances of the probate and the local rules. Those letters are what's going to allow your loved ones, if your estate is going through the probate, or if you're the loved one who had a parent, for example, whose estate needed probating, that's what's going to allow that person to access bank accounts, to make transactions on behalf of the estate. That's what's going to be issued after the initial filing of all these court documents. So you're paying attorneys hourly to do this work, and it gets filed. Some counties will have an in-person hearing, some counties will have a Zoom hearing, some counties will do it without a hearing. It all depends on where you are and the circumstances. But let's say you get those letters of administration. Then your attorney is going to have to publish on the public record, usually a newspaper, for 3 weeks here in Illinois. This is going to, again, vary from state to state, municipality, or county to county. And that's going to let any creditors know that, hey, Brandon's gone, here's where we need to go to make a claim against his estate. That publication date is very important. That date that's first published is going to trigger the creditor window. And now we're at the crux of what probate really is, if you want to ask my cynical mind about it. Probate is essentially a creditor window so that claims, debts that are owed to creditors from your estate can be orderly paid out from your estate assets. In Illinois, you have a 6-month creditor window. In other states, you have a 3-month creditor window. And 3 to 6 is the most common range. But again, this is an issue you want to check on specific to your area. Hopefully, you do nothing for this amount of time. Hopefully, nothing comes in. Hopefully, there's no surprise unknown creditor out there that sends a claim against your estate. And this, by the way, includes the cousin who says, hey, I loaned Brandon money in 1998 so he can go to the Final Four. And I want that money back with interest. Well, that cousin would have to provide the right documentation, and the judge would have to buy it and issue a valid claim. But that kind of stuff can come out all over the place. So you have that creditor window. Hopefully you're sitting here, nothing happens. Now you have the end of the creditor window. Your attorney's now going to file all the kind of paperwork again to close the estate and finally be able to distribute things. That's the probate process. Is that not enough to say, that seems a little much for me and my family? For a lot of my clients it is, but wait, it gets worse. So the expense involved. What does all this cost, this process? Nationwide, if you Google this thing, you'll eventually probably see a figure 4 to 7% of an estate is what you can count on towards probate. That may be true. First of all, though, that's a wide range. That's almost a double range, right? If 4% could be $1,000, then 7% is going to be almost $2,000. What I think is more fair in our area is going to be that $5,000 plus area in suburban Chicago here. In other states, smaller states, some of their probate process is so streamlined that I've seen you can get away with probate for a few $100s or $1,200. I would be skeptical in Illinois about that, but I wouldn't be surprised to see other states really streamline the thing to make attorneys' time less necessary, and probate can be simpler. This is also going to depend on the local filing fees for filing probate, all those types of things. Another part of the cost that you want to consider is if you will be required to purchase a bond or a surety. Lots of times good wills, like the ones I would like to draft for a client, will waive that requirement, but many states have requirements that, absent anything that a will would say, you have to get a bond or a surety, an insurance policy for the value of the estate, so that if you as the executor just abscond to Panama or something with all the estate's money, there's this insurance policy to pay off creditors and beneficiaries who might otherwise have claims. So that's going to cost you money if that thing is not waived. You're going to maybe have accounting fees, from an accountant doing a final return for the person who's passed away. All these things add up where you're going to be spending, I would think, again, upwards of $5,000, $6,000, $8,000, and there's no cap on the costs. If there's controversy, if there's litigation, if there's contested claims, if there's contested wills, all these are going to drive up the cost of probate. So how are we doing so far? We got a long time and a cumbersome process, and we have a good amount of expense. Which one of those are you in love with? But wait, it gets worse. There's also the public nature of probate. Probate is a court process. Unless there's something else going on, all these records are going to be public. meaning you and I can take a field trip down to the county courthouse and see most everybody's estates that's had to go through probate. We can see documents, we can see their beneficiaries, we can see the value of their estates. That's a lot of personal information out there. Addresses, phone numbers of your beneficiaries are commonly on some of these filings. So if you want to keep information private, you don't want probate. So those are the three main things. Again, which one of those do you love? That's why people are coming to me asking about, how can I avoid probate? Usually we use revocable living trusts with a will and with powers of attorney to make sure somebody's estate plan is put together right. There are a couple things I haven't touched on that I just want to touch on before we wrap up here. In my example, I assumed you had a will, right? And I told you the will, what it does is going to override the state's rules when it comes to who gets what after you're gone. The alternative, of course, is not having a will. Not having a will is going to require what's called intestate probate, where the state's rules are now dictating who gets what. This is going to be a more cumbersome and more expensive process because you're not going to have the will to streamline and override these state's rules. Maybe it's about sureties, maybe it's about spousal shares, maybe whatever it might be. You don't have the will to show your intent to the judge, and so the judge is going to be far more likely to require supervised or other more burdensome forms of administration of your estate, meaning more hearings, more accountings, more check-ins, which are going to drive this cost up. So when you don't do anything, when you don't even make a will, you are putting your family, your loved ones, whoever that might be, in positions to getting less. And again, is that going to fill you with the warm and fuzzies? No. So if we're stacking up things here that we can ask, how good is that for you? We can start with, do you want your loved ones to be left up to the state's rules and have the highest cost possible for your estate? Probably not. Okay, better yet, let's put your wishes down. Let's streamline things with a will. Are you still comfortable with the expense and the time involved, the public nature of a probate process? Maybe, maybe so. Some people's attitude is, hey, I'm gone. What do I care? That's legitimate. It's your money. You can make that choice. But if not, then we get to more of the land of revocable living trusts, along with a will, properly funded to make sure that you can avoid probate. So that's it for today's video. I really do appreciate you spending this time, especially with all the technical terms and everything, talking about probate of all things here today. If you feel this video has earned it, if you can give us a like, if you can give us a subscribe, if you can hit that alarm bell to get reminded of when we post new videos every month, I would appreciate it. I think I'm giving you good information. Have a good day. Be kind to everybody.